Welcome to The Explainer. Today, we're diving into a landmark UK legal case that, believe it or not, started with a fox hunt, but ended up questioning the very foundations of government power.
So it all kicked off back in 2004 when the government passed the Hunting Act. Now, this law banned the traditional practice of fox hunting with dogs. And it wasn't just controversial, it sparked a massive debate that really split the country right down the middle.
But here's the thing, this was never really just about animal rights versus rural tradition. The real story here is how this whole thing escalated into a huge constitutional crisis, one that forced the UK's highest court to ask a really fundamental question. Is Parliament's power actually unlimited? To really get how a fox hunt could lead to a constitutional showdown, we've got to look at the political firestorm that started it all. The debate over the Hunting Act was incredibly heated. It was this classic showdown of values. On one side, you had people who saw it as a vital part of rural heritage. On the other, people with really deep concerns about animal welfare. And for years, Parliament was just stuck. The House of Commons would pass the ban, and then the House of Lords would just block it, over and over again. So, to finally break this stalemate, the government decided to reach for a very powerful and very controversial tool. And understanding this tool is the key to the whole legal challenge that came next. Okay, so this whole thing hangs on something called the Parliament Acts. The story starts way back in 1911, with an act designed to stop the House of Lords from endlessly blocking the elected government. Then, get this, in 1949, the government used that same 1911 procedure to pass another Parliament Act, which cut the Lords' power even more. So, fast forward to 2004, and it's this 1949 procedure that was used to finally force the Hunting Act into law. Here's a way to think about it. That original 1911 Act, it was like a special key that the House of Commons had, a key that could bypass the lock that the House of Lords kept putting on legislation. But this brings up a fascinating and kind of mind-bending legal puzzle. Was it actually legal for the Commons to use the 1911 key to create the 1949 Act, which was basically like a machine for making an even more powerful key for itself? That was the explosive question that ended up in court. And that question became the absolute heart of a legal challenge known as Jackson versus the Attorney General. It was brought by people who supported fox hunting, and they basically argued the entire Hunting Act was built on a legal house of cards. So the legal battle really boiled down to this. On one side, you had the challengers, led by Jackson, who said the 1949 Act was totally illegitimate. They argued that the original 1911 key was never supposed to be used to forge an even stronger one. And if they were right, well, the Hunting Act would just crumble. But the government's defense was pretty simple. The 1911 Act never said what it couldn't be used for, so everything they did was perfectly legal. All right, so the case goes all the way to the highest court in the land. And while their main ruling on the Hunting Act itself was clear, it was the stuff they said on the side, their commentary, that contained a constitutional bombshell. Okay, first things first, the simple part. The court sided with the government. They ruled that the 1949 Parliament Act was valid, and because of that, the Hunting Act, passed under it, was also valid law. The fox hunting ban was here to stay. But this is where the hidden message comes in. In his judgment, one of the top judges, Lord Steyne, wrote that the classic idea of the supremacy of Parliament can now be seen to be out of place. Now that might sound a bit dry, but in legal terms, that was a huge statement. It was the highest court suggesting that maybe, just maybe, Parliament wasn't all-powerful after all. See, for centuries, the absolute bedrock of the UK's unwritten constitution has been this idea, parliamentary sovereignty. It basically means Parliament is the boss, it has the ultimate power to make any law it wants, or get rid of any law it wants, and nobody, not even the courts, can overrule it. But in the Jackson case, the judges sent out this subtle, but really powerful warning. They kind of reminded everyone that, hey, this whole idea of parliamentary sovereignty, it was a principle the judges developed in the first place, and they said it's not absolute. They even floated the idea that if Parliament ever passed some truly extreme law, like, say, a law that got rid of the courts altogether, then the courts might actually have a duty to step in and say, no, you can't do that. So, you see how a case that started with a ban on fox hunting ended up completely redrawing the constitutional map of the UK. It raised this massive question about where power really lies. The Jackson case really represents this potential shift in a very delicate balance. It puts Parliament's right to make any law it wants on one side, and the fundamental principle of the rule of law, which the courts are there to protect, on the other. And for the first time, it looked like they might not be partners, but maybe even rivals. So, if you take just one thing away from this whole story, it should be this. While the fox hunting ban was upheld, the case is remembered because the UK's highest court opened the door, even just a tiny crack, to the idea that Parliament's power is not infinite. They signaled that some things might be so fundamental that even a supposedly all-powerful Parliament can't touch them. And that leaves us with this profound and still unresolved constitutional question for the future of the United Kingdom. If Parliament isn't all-powerful, who decides where the limits are, who gets to guard them, and who has the final say? That's the huge question this fox hunt left for a nation to answer.